Imagine opening your mail one day and finding a demand for $100,000. It's exactly what happened to me. The letter was from a local homeowners association, claiming I owed years of unpaid assessments, plus a ton of fabricated penalty interest. They were threatening to foreclose on my home, a home that had been in my family for decades, long before their subdivision even existed. The craziest part? I had never signed any covenant, never agreed to be part of their HOA. My property legally predated their entire development, but that didn't stop them. They were aggressive, threatening immediate court action. My neighbors were sympathetic but pessimistic, whispered that fighting an HOA was a fool's errand, a bottomless pit for money and time. Everyone said it was better to just pay up. But something about that $100,000 figure felt so wrong, so predatory. Instead of panicking, I decided to get methodical. I sat down and read every single word of their legal complaint. And that's when I found in a tiny detail, a critical assumption buried deep in the legalese. They claimed that my property deed automatically referenced their recorded declaration of covenants. They were essentially saying that by owning my house, I was automatically a member, whether I knew it or not. This was their entire case. So, my first move was to find the truth. I dug through old storage boxes and pulled out my original title insurance policy. Then, I went down to the county records office and ordered a certified copy of my deed. I needed to see exactly what the official legal description of my property said. Spreading the documents out on my kitchen table, I started comparing them, and the story they told was completely different from the HOA's. My property's legal description, the parcel number, ended in a distinct subdivision code. The HOA's declaration, on the other hand, only covered lots that started 3 whole blocks to the east of me. How could this be? The answer lay in a document filed 20 years earlier, a boundary replat. A replat is an official redrawing of property lines. This one had been filed with the county and had permanently separated my block from their new development. Somehow in their rush to collect money, the HOA had either missed or completely ignored this recorded amendment. I took everything to an attorney. She had this calm confidence that immediately put me at ease. She reviewed the survey map. A slow smile spread across her face. "They've made a big mistake," she said. She requested one more document from the county archives, just to be sure. It was the original replat approval, signed and stamped by the city's planning commission. That single page was the smoking gun. It redrew the jurisdiction lines with unmistakable clarity, showing my property was completely outside their boundaries. We attached certified copies of my deed and the replat document to our official response to the court. You'd think that would be the end of it, right? Wrong. The HOA and their lawyers were so confident, so arrogant that they pushed forward with the first court hearing anyway. Their attorney stood before the judge and argued that my membership was implied, simply because my house was in the same general neighborhood and looked similar to the others. It was a flimsy, desperate argument. The judge, thankfully, was not impressed. He cut right to the chase and asked the HOA's attorney to produce the recorded covenants that were specifically tied to my exact parcel number. They submitted their declaration, but of course, my legal description was nowhere to be found. That was our cue. My attorney stood up calmly, walked over to the judge's bench, and handed him the certified copy of the replat document. She pointed to the official commission stamp and the recording number. A silence fell over the courtroom. You could feel the shift in the air. The judge studied the map, his finger tracing the boundary lines, comparing it to their flawed evidence. The amended plat explicitly excluded my lot. The HOA's own rules only applied to the later phases of their development, not my property. Their entire $100,000 demand, the foreclosure threat, the years of stress, was all built on a foundation of nothing. Opposing counsel scrambled, trying to argue it was just a clerical oversight. In a court of law, recorded legal instruments crush assumptions every time. The judge turned to the HOA's lawyer and asked a very simple question. Did you bother to verify the property title before you filed this lawsuit? The long, awkward silence that followed was the only answer he needed. We immediately moved for a dismissal with prejudice, which means they could never bring this same case against me again. The judge reviewed the state laws for valid HOA assessments and confirmed what we already knew. Without a contractual obligation, no dues could ever be legally owed. The foreclosure threat was baseless. With a firm bang of his gavel, the judge dismissed their entire complaint right there from the bench. He then sternly warned their attorney about the potential for sanctions for filing such a reckless and unfounded lawsuit. To top it all off, all court costs were awarded in my favor. You could physically see the confidence drain from their faces as the reality of their massive blunder set in. Walking out of the courthouse was a surreal experience. Several of my neighbors, the same ones who had told me not to fight, approached me cautiously. They'd been paying assessments for years without ever questioning if they were actually required to. I shared copies of the replat document with them right there on the courthouse steps. It turned out, several of them also lived on lots that were outside the HOA's legal jurisdiction. The news spread like wildfire through neighborhood forums and email chains. An emergency HOA board meeting was called that very evening. Local title companies started frantically double-checking their association maps. Within weeks, the HOA was bombarded with demands for refunds from multiple homeowners who had been paying into a system they never legally belonged to. Their legal expenses were piling up. Their insurance carrier was starting to question whether they would even cover the costs of such blatantly unauthorized enforcement actions. But we weren't done. My attorney filed another motion, this time to have the HOA pay for all of my legal fees. The judge granted it, citing the fact that this entire lawsuit was completely unnecessary and brought in bad faith. That one single, recorded document from the county archives had dismantled their entire corrupt enterprise. We didn't need a dramatic, drawn-out trial. We didn't need to spend a fortune. All it took was accurate public records and a careful, detailed review. That replat document had been sitting there quietly in the county archives for decades, just waiting for someone to notice. In the end, the HOA had no choice but to reluctantly revise its official boundary maps and mail out letters correcting their erroneous notices. Several board members resigned under the public pressure. A new era of transparency began as homeowners started collectively demanding better governance. Finally able to refinance my home, free and clear from the false lien they had tried to place on it. My credit report was untouched, all thanks to taking swift, decisive action. The $100,000 demand vanished, as if it never existed. But what remained was a powerful lesson. Assumptions and intimidation tactics couldn't hold a candle to recorded legal facts. A single certified piece of paper can outweigh stacks of threatening letters. In court and in life, precision will always defeat intimidation. So, before you ever back down, make sure you do your homework. The truth might just be waiting for you in a dusty file at the county records office. Thanks for watching. Remember to always check the facts. And don't forget to like and subscribe for more stories like this one.